friends have been assigned a duty to explain about how a writ petition is to be drafted, that is in the Supreme Court as well as in the High Court. Now, you all must, I assume that you are all lawyers and students of law. To tell you, the lawyer consists and the advocacy consists of two skills. One is drafting and the other is arguing matters in the court. Now, someone who argues well and doesn't draft well does not make him a complete lawyer. So, if you want to be a good lawyer, one needs to develop his skills of drafting as well as arguing in the court. Now, so far as understanding how the writ petitions are to be drafted, we need to understand few concepts under the Constitution of India. We all know that Constitution of India is the longest constitution in the world. Several provisions in the Constitution are borrowed from various constitutions of the world. Mind you, don't ever consider that the provisions in the Constitution are copied. In our Constitution are copied. When the Constitution was being drafted, it took almost 2 years for all the experts to draft that Constitution. Now, for example, very interesting provisions of the Constitution, say for example, fundamental rights are borrowed from Constitution, American Constitution. Now, Article 227 of the Constitution of India was from Government of India Act 1935 with few amendments. Like earlier, the Government of India Act 1935 provided that the High Court shall have superintendence over the courts. But when Article 227 was brought in, the tribunals were also added. So likewise, the other provisions were incorporated considering the nature of our people. Now, if you all know that Part 3 of the Constitution prescribes about our rights, that's in short called as fundamental rights. Article 14 speaks about equality. Article 21 speaks about right to life. Now we all know about all our fundamental rights. Those exist in the Constitution of India. Now what happens if we have no remedy against breach of these fundamental rights? What do we do? If there is no remedy in the law and we assume we have a right, and if there is no remedy, those rights are meaningless. Therefore, the Constitution provides for remedies. Now, if there is a breach of a fundamental right or any other constitutional right, we can either approach the High Court under Article 226 or the Supreme Court of India under Article 32 of the Constitution of India. Now, you would ask me, what is the difference between Article 226 and 227? I mean, 32 of the Constitution of India. Why should we go to the High Court when under Article 32 you can go to the Supreme Court seeking the same relief? I tell you, if you approach the court, if you approach the Supreme Court directly, generally, Supreme Court does not entertain your petitions, saying because you have an alternate remedy under Article 226 of the Constitution. Therefore, and secondly, the powers of the High Court are little wider than the Supreme Court while exercising its writ jurisdiction. So far as the High Court is concerned, the powers of the High Court can issue writs if there is a violation of fundamental rights and other constitutional rights. Whereas under Article 32, the Supreme Court can issue writs only if there is a violation of fundamental right. You all must be knowing that right to property was initially a fundamental right, but now it is no more a fundamental right. So if your right to property is breached, can you go to the Supreme Court? No, you cannot go to the Supreme Court, because the Supreme Court has a jurisdiction under Article 32 to entertain a writ petition only if there is a violation of fundamental right. So in such scenario, the writ jurisdiction of the High Court is little wider, and you need to go to the High Court if there is a violation of your other constitutional rights. As you all know, there are 5 types of writs. Now, these were initially called as prerogative writs. These writs were issued by the kings against the officers to compel them to exercise their function and protect against them from abusing their powers. Now, these writs were included in our Constitution of India. Now, under Article 226 and Article 32 of the Constitution, the High Court and the Supreme Court can issue 5 writs. For example, habeas corpus, that means produce the body. If someone is detained in jail or somewhere without authority of law, then you can file a petition in the Supreme Court or in the High Court and seek writ of habeas corpus. Writ of mandamus. If some officer who is tasked with a public duty, and if he fails to do it, you can approach the High Court or the Supreme Court and seek writ of mandamus. Why am I telling you all these provisions? Why am I telling you these concepts? Because for filing a writ petition, one needs to understand. If you draft a writ petition, you need to understand the background, under which provision, under what writ you can approach the High Court, which writ you can seek from the court. The third is writ of prohibition. When you are seeking, you go to the court seeking, restraining any inferior court from exercising a jurisdiction which it does not have. Then there is a writ of certiorari and writ of quo warranto. So one has to understand the concepts before you start drafting a writ petition. This I was telling about Article 226 and 227 of the Constitution. 226 and Article 32 of the Constitution. There is one more important provision which one has to understand. Before you start drafting, you need to have a background, or you need to go through these provisions to understand what is a writ and how it is to be drafted. Article 227 of the Constitution, that is power of superintendence of the High Court over all other courts. That's one more important. This is one more important provision so far as writ petitions are concerned. There is one judgment I would suggest you people to read. That's Varyam Singh versus Amarnath. That's reported in AIR 1954, Supreme Court 215, where the Supreme Court has given the history of how this Article 227 was incorporated in the Constitution of India. As I told you a while before, Article 227 was adopted from the Government of India Act 1935 and also from the Government of India Act 1912, where the provision was similar to what Article 227 is, barring in the Government of India Act. In the Government of India Act, the High Court superintendence was only restricted to the courts, whereas Article 227 of the Constitution was provided that the High Court has superintendence over all courts as well as the tribunals. Now, when do we approach the High Court under Article 227? You will find that in one of the judgments, Achyutanandan Vaidya versus Prafulla Kumar Gavan, reported in 1997, 5 SCC 76, where a court, when a court, inferior court to the High Court, does some act which is beyond its jurisdiction or does something in excess of its jurisdiction, or it refuses to exercise its jurisdiction, or if it exercises its jurisdiction arbitrarily. So if the lower court passes an order without its jurisdiction or in excess of its jurisdiction, or as in parameter as laid down in that judgment which I just told you, you can file a writ petition under Article 227 of the Constitution. Now, turning towards drafting, as I told you, when have we started learning about drafting? We actually started when we were small young children. We were probably taught in class 1, class first, class second, how to form a sentence. That's how probably we started learning how to draft our petitions. Now, in normal parlance, drafting means something which is not final. But in legal parlance, so far as legal drafting is concerned, we call something a draft, which drafting means something which we prepare for filing in the court, or you can call it a legal document. Preparation of a legal document can be termed as a draft. Now, how do we conceptualize a draft? According to me, we can term it as a painting, because it's a skill which you develop over the years. Someone in the last lecture had asked me, is there any book on drafting? I said, no, never read a book and you will never understand how to draft a petition. A petition, you acquire the skill over the years by reading as many drafts as possible. If you are in a senior's office, you read his drafts as much as possible. And my style of drafting might be different from my senior. or some other lawyer. So that's how it is. Drafting does not depend upon, see, you may not acquire the drafting skill in a day or two. You may take years, you may take months, or I have known few lawyers who acquired the skill very early, and there are few who did not acquire for even after spending years. But I know for sure that if you have a keen interest in knowing how it is to be drafted, you will learn, you will acquire the skill as early as possible. Now, as I told you, it's drafting is like a painting. When you draft a petition, you cannot, you have to make it perfect. You should try to make it perfect. Now, how do you make it perfect? As I told you, a painting, if you are painting an elephant, you can't make the trunk too long. It will look very odd. You can't make the tail too short or the body too small. That's how a painting, a drafting is to be seen. I have seen drafts where the lawyers, there are large number of grounds, say 50 grounds, 100 grounds in the petition. That would not serve your purpose. You should know what is to be drafted. I always tell my colleagues that when you draft a petition, you should always think from the reverse direction. You think about the prayers which you are making, and then you think about the body, the grounds. Now, I always tell my friends and my colleagues that when you when you are preparing a draft of a second appeal or a revision petition or a review petition or a writ petition, you should always read and find out the scope of that provision. For example, if you are drafting a second appeal and you don't know what is the scope of the second appeal. Second appeal, as you all know, is filed under section 100 of Code of Civil Procedure. Now, if a first appeal is to be filed in the first appellate court, there you may not raise substantial questions of law. You are also entitled to raise question of fact. But when a second appeal is to be drafted, you can only raise substantial questions of law. So unless you know the scope of that provision, unless you know the scope of the second appeal, your drafting is going to go haywire. For example, if you are drafting a revision petition and you raise all the factual aspects, or if you are drafting a second appeal, you are raising all factual aspects, that is not going to help you. If you are drafting a second appeal, you have to see what is the substantial question of law. If you are drafting a revision petition, you have to know what is the jurisdictional error the lower court has committed. Or if it is a 227 petition or a review petition, you have to understand under what provision and what are the grounds on which a review is maintainable. Now, therefore, as I tell you, the most important aspect before you start drafting is understanding the scope of that particular provision. Now, another aspect which is very important, and I really feel that it is in many cases overlooked. One of my colleagues used to draft his petition in such a manner that nobody used to understand what he actually meant. He used to find out very difficult words from the dictionary and add to his draft. There are people who don't bother to make it grammatically correct. There are people who make it simple and lucid. According to me, when you are filing a petition, you should have a reasonable, good knowledge of English. Your concepts, legal concepts should be good. And your draft should be such that it is easy to understand. Why do you draft a petition? Is it to make it visible or to show that you have a great vocabulary? No. According to me, it serves two purposes. One, in a higher courts like the Supreme Court or the High Court, there's a practice that the judges read their brief at home. So, if you draft your petition well, if you can make out a point, if the judges understand what you have said, they would probably be on your side when they come to the court the next day. Second purpose it serves is it gives a sufficient notice to the other side what you actually mean, so that the other side is able to respond. Now, if your draft is such, which is not very clear, which does not give a correct perspective of you, what you actually mean to say, it's not going to help you at all. This is one important aspect a lawyer, a new lawyer should understand when he drafts a petition. I go a little further. When we go to the courts and we argue matters, even before the court, you should try to make it simple and not to complicate the thing. If your drafts are complicated, if you argue the matter in a complicated fashion, then probably you would not be able to seek the relief from the court. If you make the petition in such a manner which are simple and easy to understand, the probability of getting a relief is much more than what you would probably by making it little difficult. Now, the other factor which is very important when you draft a petition is about clarity of facts. Before you draft, you should be clear on the facts, and that is equally applicable when you go to the courts and argue your matter. As I told you, the advocacy is arguing in matters in the court as well as drafting your petition. So when you are clear on the facts, you would probably draft it better. Now, how do you do it? How can you be clear on facts? Because when a client comes to you, he may not be as qualified as you are. He might be a person, he might be a rustic villager. He would carry a bunch of paper and keep it in front of you. Now you need to assess the documents. You need to understand the facts. If you understand the facts, well, you would be probably able to draft your petition. Now, how do you start your drafting when a client reaches you and gives you bundle of documents and bundle of facts? How do you start it? How do you start your drafting of your petition? The first and foremost thing is you should write down the events chronologically. You should arrange the documents chronologically. I have seen few petitions where the chronology of events is missing in the petition, or the documents are not annexed in chronology, it only adds to the confusion. Now, if you annex the documents in chronology, probably you would be able to assist the court in a better way. Now, why are these documents important? If you file a petition, is it not enough? You file a petition and you don't annex these documents. As I told you, in the writ courts, there is no evidence left. What is the evidence? The document. If you miss out the most important document and go to the court, will you be able to show? Will you be able to prove your case? No. Therefore, annexing important documents and not missing out the important documents is a very important aspect one needs to remember. Now, another important aspect. Now, what happens? Sometimes we are lured by, say, if in initial days or before you become a lawyer or a layman, always feel that in courts everything is a lie. One who lies better becomes a good lawyer. That's a concept people carry, or that's an impression people have in their minds. But I tell you that that's a big no if you go to the court and make a misleading statement, make a false statement in a petition. You are going to lose out only on that ground. If the statement made by you is misleading, then the court is bound to hold against you. There is a concept that if you are approaching the courts of law, you should approach with clean hands. I'll give you one example. There is one case, there is one case, K. Jairam versus Bangalore Development Authority, that's reported in 2021, SEC Online 1194. Now, in this judgment, the petitioner's land was acquired. He challenged that acquisition before the High Court and raised all his grounds, stating that the acquisition was not proper, it was not in accordance with law, and therefore deserves to be quashed. The court really got impressed by the submissions and called upon the other side, that is Bangalore Development Authority. When the Bangalore Development Authority appeared, they filed their response, they filed their reply, and pointed out that the petitioner therein had suppressed that there was a suit filed earlier between the same parties, and the petitioner had lost the same. The appeal filed against the said judgment was also decided against him. When the court found that the High Court dismissed his petition, maybe he had a right, had he brought to the notice of the court that this suit was on different aspect, or the reason behind not mentioning in the petition, probably he would have, reason for filing such suit, he should have mentioned it in the writ petition. That would have given little hopes to him. But once he suppressed, the court felt that he had deliberately suppressed the facts from the court, and on that count alone, the writ petition was dismissed and the Supreme Court confirmed the judgment of the High Court. Now, this takes me to another aspect about pleadings. So, while pleading in the writ petition and the plaint in the suit are little different. In the plaint, you cannot miss out a point. But for a writ petition, strict concepts of pleading are not applicable. The writ courts are generally liberal. In the Bombay High Court, till recently, people used to draft the writ petition like an essay. But very recently, the Chief Justice of Bombay High Court issued a notification and instructed that the writ petition should not only contain the factual aspects, but grounds also should be raised. In the writ petition in various, the way of filing of writ petition in various high courts is different, but broadly it should contain the facts, the grounds, the documents, and the prayer. So therefore, strictly speaking, the concepts of the pleadings, the courts are little liberal so far as writ petitions are concerned, pleadings in the writ petitions are concerned. Now, one more aspect about if you miss out the pleading, what happens? If you miss out an important plea, say for example, if you are wrongly terminated and you approach a tribunal, if you are a teacher and you approach a tribunal seeking reinstatement, you file a petition and do not mention that you were not employed anywhere else after you were terminated, you are going to lose out the back wages are concerned. So one has to understand and read the existing law when you draft a petition. Now the law is, if you are an employee and if you are terminated, if you go for seeking a reinstatement, you should mention in the petition that you were not gainfully employed anywhere else during the pendency of the proceeding. Otherwise, you are terminated. You go and work somewhere. That would disentitle you from claiming back wages. That is the reason why while you file a petition, you should actually know what the law is, what the law exists. If you miss out in mentioning this very one sentence, you might lose out the main prayer, claiming back wages. So that is one of the aspects which one needs to consider while you draft a petition. Now, it takes me to another provision, another part of the petition. That is prayers. I told you about factual aspects. I told you about the documents, how it is to be annexed. I told you about the chronology of events. The most important part in the petition is prayers. I told you that I often tell my colleagues that when you draft a petition, you should actually think about the prayers which you are making. If your prayers are inconsistent to the pleadings, probably you may not get a relief for your client. What happens if you miss out a prayer? If you don't make a prayer, for example, as I told you, if your client is terminated from service and you file a petition seeking reinstatement, you also mention that he was not gainfully employed. Now, if you have stated everything, but you forgot to mention about back wages, what happens? Are you going to get it? No. You have to draft your prayers by, if you miss it out, you would probably not get a relief, and that would be a ground for the other side to raise an objection. So the most important aspect is about the prayers. Now one more aspect which I really missed while telling, or before that, I'll just conclude other aspect. The very aspect of prayer. Now you make a final prayer in the petition, but you miss out an interim prayer. What happens? You might not get an interim prayer. For example, if you are seeking transfer of proceedings from one court to the other, and you miss out seeking stay of the proceedings, the court is not going to grant it. Because unless you make a prayer, you are not going to get a relief. And by that time, probably the petition would become infructuous. So it is also important to make proper interim prayers. Interim prayers, now, if you have completely different grounds and your prayer is inconsistent to the ground, the court are again not going to grant it. The interim prayers should be always in the aid of final relief. So the interim prayers also should consider, you should also consider while drafting your prayers that they are not in conflict, or they are not inconsistent, or they are related to the grounds raised by you. And the interim prayers should be in the aid of the final relief. Now, if you are seeking some one final relief, you can't claim interim relief something which is not related to the final relief. So therefore, while understanding the concept of drafting, the prayers are the most crucial aspect. Now, it brings me to the jurisdiction and the parties. Whom do you make a party in the writ petition? If you forget to make the if you don't make the necessary parties to the petition, probably that would be a ground for dismissal of your petition. So one important aspect, your draft might be all right, might be fine on all aspects, but if you don't make a necessary party, then probably there is one more ground that would be one of the reasons for getting a petition dismissed. The proper and necessary parties is one of the important aspects when you learn the skill of drafting. Another aspect is about jurisdiction. You all know that high courts have territorial jurisdiction. If the cause of action has occurred in Delhi, you would not be able to file a petition in the jurisdiction of Bombay High Court. So one has to understand in which jurisdiction the cause of action has occurred. Now, another aspect is about limitation. When you file a writ petition, there is no limitation provided under the Constitution of India for filing a writ petition. But does it mean that you can file a writ petition at any time? It has to be filed in a reasonable period. Now, you need to mention in the petition that why did you approach the court after a particular period? You need to give an explanation. Say, if you are claiming reinstatement, as I told you, and you approach the court after 2 years, you don't mention the ground in the writ petition. What happens? If you don't mention the ground for the delay, your petition might get dismissed. So therefore, one another aspect, while preparing the draft, you should always keep in mind that your petition, if it is related, you need to give a proper explanation. Now, this writ petition is there is one other petition which we all know, apart from the writ petition, apart from the writ petition under Article 226 and 227. We also file public interest litigation. Now, public interest litigation is a concept which is familiar to American jurisprudence. In 1976, Justice Krishna Iyer is the founder so far as public interest litigation is concerned. Justice Krishna Iyer and Justice Bhagwati are the founding fathers so far as PILs are concerned. Now, I probably missed to tell you that when you file a writ petition, you also need to mention that you have a locus standi, your client has a locus standi or right to approach the court, barring writ of quo warranto. If someone is holding an office illegally, any citizen of India can file a petition. But so far as other writs are concerned, say for example, writ of mandamus or certiorari, you have to mention that you have a locus standi to approach the court. If you don't mention whether you have a locus standi, and if you don't show that you have a locus standi, probably your petition would get dismissed on that count alone. Now, the way for a quo warranto, you don't need to show your locus. Similarly, in public interest litigation, you need not mention that you have a locus. I mean, you are filing a public interest litigation. That is, we mentioned in the so far as Supreme Court is concerned, we title it as a writ petition only. But in the High Courts, it is titled as PIL. Now, so far as PILs are concerned, You are filing it, the petitioner is filing it on behalf of others who are not in a position to approach the courts of law. It actually started in 1976 in Hussain Ara Khatu's judgment. You all must be knowing, in that judgment, there were 17 prisoners who were confined in jail, and their trials were not getting proceeded. The one lawyer named Hingurani filed a petition in the High Court on behalf of those 17 prisoners and told the court that, see, right to speedy trial is a fundamental right under Article 21, and therefore they need to be released on bail. The Honorable Supreme Court of India accepted the plea and released all those prisoners on bail by recognizing that right to speedy trial is a fundamental right in terms of Article 21 of the Constitution of India. Now, therefore, so far as locus standi is concerned, that is relaxed so far as PIL is concerned. I must add one more thing. While this Hussain Ara Khatu's petition was filed, there were large number of letters which the Supreme Court had received, and letters were treated as public interest litigation. And that's how the Supreme Court entertained those letters as PIL and allowed those petitions. So, but as a lawyer, are you only required to mention, or are you required to only bring it to the notice of the court by a letter? According to me, if you are a lawyer, you need to understand the concept of PIL before drafting the same. For a PIL, the first and foremost thing a lawyer needs to understand is that there is no private interest involved in the petition. If there is a private interest involved, if the petitioner himself has some remote interest in the list, then it cannot be termed as a PIL. And if you file it in the nature of a PIL, you would probably get it dismissed with cost. Now it takes me to the other aspect, that is drafting of review petition. As I told you in the beginning, one needs to understand the scope of each provision. If you are drafting a 482 petition for a quashing petition, you need to understand the grounds on which you can file the petition. The scope of that 482, section 482 of CRPC. Say an FIR is registered against you. You don't want to face a trial. You can go for quashing of that FIR. But it's not that in all on the registration of all FIR, the quashing petition would be entertained. Therefore, you have to understand the scope of section 482 of CRPC. The scope is if there is an abuse of process of law, or if no offense is made out, only then 482 petition is maintainable. Likewise, if you are drafting a review petition, you need to understand Order 47. If you read Order 47 of Code of Civil Procedure, you would get the grounds on which you can file a petition. Say, for example, error apparent on face of record. So you need to point out, because review jurisdiction is such that you have to file a petition before the same court, that there is an error apparent on face of record, and therefore your judgment needs to be recalled or reviewed. Second, if there is something new which was not available at the time of when the order was passed or when the matter was argued, there's another ground. So therefore, one has to understand the scope. Even for drafting a review petition, you need to understand on what parameter a review can be filed. It is not an appeal, as Supreme Court has time and again said. You can't raise the same grounds what you have said in your appeal or in a original petition. If you don't understand the concept or the scope of that proceedings, you would probably not make out your case, and on that count alone, your review petition may get dismissed. There is in late during in 1998 probably, the Supreme Court came out with another concept. In Supreme Court, as you know, under Article 136, the special leave petitions, they can be filed. Now, after dismissal of special leave petition, there is a remedy of filing a review petition. As I told you, it strictly in terms of Supreme Court rules and Order 47 of Code of Civil Procedure. If your review petition is dismissed, there is one more concept which the Supreme Court has evolved, that is curative petition. Curative petition is maintainable only in the Supreme Court. Now, all these curative petitions are entertained or are maintainable if only there is a breach of principle of natural justice. For example, if the judge is biased, if he has a pecuniary interest in the list, in the property of the list, or if the person concerned, if the affected party was not at all heard and the judgment was delivered against him. So therefore, in short, even for filing a curative petition, one needs to understand the concept behind filing of the curative petition. So it can be filed only when there is a breach of principles of natural justice. So your grounds should mention that it falls in the category mentioned in Rupa Hurra's case, where the Supreme Court has given in detail on what basis the curative petition is maintainable. This is what I wanted to tell you about drafting of writ petition, PIL and review petition. If you have any query, please let me know.
Yes, thank you so much, sir, for this enriched session. I will just verify, update this setting of the Zoom so that the participants can unmute themselves and can ask any query if they are having.
Right.
Yes. So,
sir, may I question?
Yeah.
Sir, can you explain once again what is the meaning of interim relief and what is the importance in interim relief in prayer and final relief?
See, final relief is when your petition gets disposed of. The relief which you see when your petition is disposed of. But during the pendency of the petition, say for example, your house is getting demolished. You go and file a writ petition. If the municipal corporation has approached, has started demolishing your house without giving you a notice or without following a procedure, you go and file a writ petition in the High Court. Now, till the time your writ petition is finally decided, the relief which you seek during the interregnum is called interim relief. You will go and tell the court, please stay the demolition. That is called interim relief. There is also a concept of ad interim relief. Now, when you file a petition, you claim ad interim relief. Relief till the other side approaches, till the other side is served. Once the other side approaches, once the other side is served and they file their reply, then again that ad interim relief is confirmed and is made an interim. Right? Hope I have made it clear. Is there anybody else?
Sir, can you hear me?
Yeah, yes.
In a writ petition, how should we lay out the facts?
I told you, you have to lay it out in chronological order. You have to annex the document in chronology. So that factor you should always keep in mind. It always has to be in chronology, unless it is required otherwise. Say for example, 1st of January 2021 has to be first in time. Then 10th of January 2021 has to be later, like that.
Thank you, sir.
Shri,
Yes,
interim
is there
relief
any other query?
claimed in interim application.
Well, sir, habeas corpus on the government officers, you told, you taught me or at your speech. So can it be once again discussed regarding habeas corpus against the government officer?
I didn't get you. See, habeas corpus is a concept, a writ where someone is detained without authority. Now, you must have heard about petitions being filed where a minor is abducted or is not found. We can file a petition in the High Court under Article 2 to 6 and seek directions against the police to produce the body. Right? Hope you have understood. If, for example, even if the police detain someone without the authority of law, you can say without registering an FIR, without the authority, you can file a petition under Article 2 to 6 or under Article 32 and seek writ of habeas corpus.
That means it will be against government authority.
Yes, yes, yes. Now one has to understand, when you file a petition, it is always, writ petitions are always against the state. You can, in some cases, you can file a petition against a private entity if the functions which they are, if the functioning is under deep and pervasive control of the government, or if they are receiving funds from the government. Otherwise, writ petitions are maintainable under Article 12 only against the state. Article 12 mentions the definition of state. So, writ petitions can be filed only against the state. Is there anybody else?
Thank you, sir.
Thank you so much.
Good evening, sir. Sir, can you please show some drafts of writ petitions?
See, I tell you one, if you join your senior, you will get to see as many drafts as possible. By seeing one or two drafts, you would probably not understand how it is to be drafted. But if you all want, I can share it to the madam who is organizing this program.
Yes, sir. It
Hello.
will be very helpful for us.
Yeah, you can contact her.
Hello.
And send her a few drafts.
Hello, sir, am I audible?
Yes.
Sir, I need to ask that while drafting writ petition, is it a good practice to mention case laws in the draft?
See, it really depends upon you. Like in the plaint, you don't need to mention the case laws or law. In the writ petition, you can always mention, and because the judges of the High Court and the Supreme Court read and come, you can also annex the judgment to the petition. If it is covered, if the issue is covered by the Supreme Court or the High Court judgment, you can always annex it to the petition.
Yes. And is it better to annex those judgments in the facts or in the grounds?
No, it's always in the body of the petition. Annexures are always in the body of the petition, not in the grounds.
Sir, I have
Okay,
seen
okay.
in
Thank
the,
you so much. Thank you so
High Court, they sometimes calls, let me see the books in which page. If we place the Xerox copy of taken out from the Google or from any.
No, you can't really. You
It's
can't
not-
produce such document which has no source, which you need to have. See, those books and the judgments have to be reliable. You can't produce something and rely on something which you do not know who is the author of it. Right?
We have mentioned it. It is taken the copy from so and so source and the site also, but it was not accepted. Always told us you submit the books and with page.
That is always better. You should submit books.
Is it possible to collect all the books?
You can get it from the library. You can request some lawyer. You can get a printout of it.
Thank you, sir.
Mr. Abhishek Mishra has some query.
Yes, sir. The participants, you are allowed to be unmuted.
Hello.
Hello, sir.
Thank you so much.
Hi, good evening. I have a query.
Hello, sir.
Yes.
Hello.
Yeah, you had mentioned that in PIL, the petitioner should not have any personal interest. What do you mean by that? What are you referring to? What kind of interest? Because sometimes a petitioner has interest in the issue that's going on. So,
Yes, exactly. But that his interest should not be the only interest in the petition. Say, for
Okay.
example, if he is one amongst 100 people whose houses are getting demolished, and those are illegally demolished, those people cannot approach, then he may file a petition. He can tell the court, he should mention in the petition that even my house is getting demolished. But say, for example, if I have a contract and I file a petition, let's say, for example, if I don't get a contract and someone else gets a contract, I file a writ petition posing as if I have a public interest. This contract should not be awarded. I have a personal interest in that list. Therefore, in such matters, once you show that there is a personal, once it comes to the knowledge of the court that there is a personal interest involved, the court would dismiss your petition with cause. Therefore, in such matters, you can of course file a writ petition, but not a PI. You should avoid filing PI in such case, where you have a personal interest in the list.
okay, not
Hello.
having full interest, right?
Right.
Got
Hello.
it.
Excuse me, sir.
Yes.
Hello,
Sir,
sir.
I have a query.
Sir,
If
in a
is there a way-
proceeding,
is there a way to
Yeah,
file an
in a proceed. Please go forward.
Sir, is there a way to file an amendment if I have missed some facts or
Yes,
something?
of course, you can file an application seeking amendment, and if the court permits, you can get your petition amended.
And that application is filed in the which section? Which article, which section?
No, there is no such article. It's inherent jurisdiction which may permit, because strictly speaking, the provisions of CPC are not applicable, but wherever it is necessary, the provisions of CPC can be applied.
Okay, sir. Okay.
Sir,
Abhishek Mishra has some queries.
sir, there's
So I
one.
have,
There's
I have a
one.
query in terms of, how should we go about making the drafting, because when we get the file, especially in Supreme Court, we get it, we have to file the SLP. So how should we go about reading it and then preparing the plaint? Because as you rightly mentioned that we have to look at the prayer first and then we can go for the grounds and all. How can we take grounds from the judgments or the precedents as well?
When you're filing a petition, say for example, if you're filing a special leave petition, I always advise my colleague that when you go through the order of the High Court, you should first note down what all the points are against you, and then find an answer. Second, you should also see to it that what all the grounds you raised before the High Court, which are not at all considered by the court. So you need to first jot down the points on which the High Court has gone against you and find an answer over it. Second, also consider those points which are not looked into by the High Court. Right?
Right. Thank you so much, sir.
Sir, I was asking, whatever we are discussing here, these are all found in the books. Exactly what is a writ petition and the review bit and all. What I would like to know is, sir, when these matters are being put up in court, exactly in the moot form basis, can we hear something from you, sir, where any particular case, how you're presenting it in court and what are the backlashes or what the respondent is answering you? Because then if we get a live session, something like that, we can corroborate it with your material which you have given us today. Because these are all things which we are on top we are hearing. Like for example, as in a debate, whenever any particular topic is picked up, what the opposition or the respondent is speaking, if these we go through along with what you're giving, then only I think, sir, we can really gain. Because
Right.
no senior, sir, immediately tries anyone to get independent. I hope you can understand what I'm trying to say.
I understand it, but then
And then that means we'll never be able to get any party directly coming to us because we are afraid that we will never be able to represent them well and we'll always have to depend on a senior. Then the entire thing is just knowing the things and not being able to actually practically put it into use. If you could have these live sessions where you corroborate it with a particular case, where you're saying this is what
Dear participant, we don't have that much time, so please brief your questions. Sir has got your question. So let us consume some time, okay? Sir has got your question. Thank you.
Sir, please tell us.
Yeah, madam, we can do one thing. I can send you, say, you can get the links of the Supreme Court live streaming on Mondays and Fridays. And secondly, you can also, there are Gujarat High Court, there is a live streaming of the High Court proceeding. You can watch those proceedings, probably you will get to learn few things. Or the other thing which you can do is you can sit in the courtroom. If you have joined some senior, you can assist him in the proceeding. And that's how you learn and that's how you pick up. Because on the first day, nobody is going to give you a brief. Because even, say, your relatives would not be able to give you the brief because they would want some experience on your part. So that's how it happens in the courts of law. Everybody wants an experienced lawyer. So once you put in few years of practice, you would probably get all kinds of matter. Right? If you want to understand how the proceedings go on, you can go to the Gujarat High Court website. You will be able to watch it.
Madras High Court website.
Yes, Madras High Court, Gujarat High Court. There are various high courts which are coming out with live streaming. You will be able to understand how it is, how the procedure goes on in the court.
Thank you, sir.
Sir, excuse me, sir.
Yes,
Sir,
yes.
documentary evidence should be annexed with the petition.
Documentary, yes. If you are relying on it, you should annex it.
Okay, sir. Thank you, sir.
Is that okay? Is that all?
Excuse me, sir.
The question, sir, the writ petition
Audible,
should
sir?
be longer than the normal petition. The writ petition should be longer than the pleadings, the normal pleadings,
No,
or it
no.
should be short.
So it really depends upon you. I know a lawyer whose petitions are very short, but he makes out a point in that petition. You don't need to make the petition long.
Thank you so much, sir.
Yes,
Excuse me, sir.
yes,
Good evening, sir.
yes.
Generally, whenever we purchase some material from the like Reliance Trend or any other big bazaar, the bills what they will provide, it will only act as a evidence in the court after the signature and seal of that shop. If they are not able to provide that, is it applicable or not?
I didn't get you.
Sir, generally when we purchase the...
I think you are asking some personal question of yours. You please restrict yourself about drafting. That will be better.
Okay, sir.
Yes, please ask the question which is relevant, which is regarding to this particular session.
Okay, sir. Thank you. No problem.
Thank you so much.
Yes.
There are-
Writ petition is always against the article of the state. The article
Thank you
12,
so much, sir.
the things mentioned in the state, the defined in the state in article 12. Writ petition is always against the state. Not we cannot file writ petition in the consumer forum. Is it so, sir?
No. It's only in the High Court and the Supreme Court.
Thank you, sir. Thank you.
One has to read Article 226, Article 227, and Article 32 of the Constitution.
Thank you.
Yes. Is there any other query which is regarding with this session? Yes, I guess there is.
Sir,
There is
when
no
the
any more query.
party, when we are enumerating the parties in the writ petition, what is the linkage or what is the their deciding what which is first?
For example, if you are filing a writ petition, say if you remember the Arnab Goswami's writ petition, he had filed a petition saying that he has been wrongly confined in jail. He had also sought for quashing of the FIR. Now, in that petition, he must have made the Home Department of State of Maharashtra. That's how you have to identify the party. So, in that writ petition, he must have made writ petition the State Home Department of State of Maharashtra as party respondent, and he must have sought relief against them. Right? I have not seen his petition, but that must have been his prayer, and that's how that must have been those. The Home Department must have been the party. Like that.
Okay, so
You need to identify against whom you are seeking a relief.
okay. And Home Department, that department which related to the
Represent
case.
to their lawyer.
Okay,
They will be
department and then
represented to their lawyer.
okay.
Is that all?
So just wanted to give you a thank you, sincere gratitude from our side.
Thank you so
Yes,
much.
so enough time has been given to all the attendees. So thank you so much, sir, for addressing each and every query. Thank you so much for giving your valuable time. Dear participant, please, if you have any query, you just mail on the legal expert sheet. We will address it to the sir.
Excuse me, ma'am.
Yes.
Ma'am, we will get the certificate after tomorrow's session, right?
We will discuss these things. All the things will be given to you on your proper communication, through the proper communication. Okay. So
Right,
do
madam.
not worry about
much.
it.
Thank you so much.
Yes, thank you so much, sir, once again for this such a wonderful session, such an engaging session. Thank you so much, sir.
Thank you.